So on behalf of the Harvard Club of Southern California, I want to thank everybody for joining us in this Harvard Speak LA virtual event. The Harvard Club of Southern California is one of the largest and most active Harvard alumni clubs in the world, and we're delighted to be able to sponsor this event. My name is Neil Morgenbesser. I'm Harvard College class of '86 and the director of Harvard Speak LA program, which brings the opportunity to the broader alumni community for some intellectually and academically stimulating interactions with some of the most stellar Harvard faculty members. We had a couple of terrific events the last 2 months with Dr. Loretta Mickley, head of Harvard's Atmospheric Chemistry Modeling Group on wildfires, and with Professor Avi Loeb of the Astronomy Department on evidence of extraterrestrial intelligence. Our next scheduled event is a conversation with retired Harvard government professor Harvey C. Mansfield on Tuesday, April 6th. We also have commitments from English professor Stephen Greenblatt, psychology professor Stephen Pinker, and Kennedy School professor Tariq Masood. So stay tuned for those over the next few months, as well as some more in the works. Today, we're extremely excited to be able to hear from Professor Randall Kennedy. Randall Kennedy is the Michael R. Klein Professor at Harvard Law School, where he teaches courses on contracts, criminal law, and the regulation of race relations. He was born in Columbia, South Carolina, and attended St. Albans School, Princeton University, Oxford University, and Yale Law School. He served as the law clerk for Judge J. Skelly Wright of the United States Court of Appeals and for Justice Thurgood Marshall of the United States Supreme Court. Awarded the 1998 Robert F. Kennedy Book Award for Race, Crime, and the Law, Professor Kennedy writes for a wide range of scholarly and general interest publications. In a review of Professor Kennedy's 2021 book, Say It Out Loud, on race, law, history, and culture, John McWhorter said, "Kennedy is the kind of writer who gives you the sense that in the end, he's always just plain right." His other books include For Discrimination, Race, Affirmative Action, and the Law, 2013, Persistence of the Color Line, Racial Politics in the Obama Presidency, 2011, Sellout, Politics of Racial Betrayal, 2008, Interracial Intimacies, Sex, Marriage, Identity, and Adoption, 2003, and Nigger, The Strange Career of a Troublesome Word, 2002. A member of the American Law Institute, the American Academy of Arts and Sciences, and the American Philosophical Association, Professor Kennedy is also Trustee Emeritus of Princeton University. Professor Kennedy is going to discuss with us his forthcoming book, How We Overcame, Protest, Law, and the Demise of Jim Crow, and with the available time, answer questions from the audience about this topic and other topics of interest. If you do have questions for Professor Kennedy, please submit them in the chat, and we will get to them one by one after he speaks. With that, I'm delighted to be able to introduce Professor Kennedy.
Well, thanks so much for the gracious introduction and for affording me this forum. Before I go on with my remarks, I do want to note that I'm very aware of the catastrophe that overcame you and your neighbors not so long ago. I'm sure that people are still working hard to recover, and my thoughts are very much with you. Now, I'm going to speak for a while about a project that I've been working on for a bit over a decade. It's a book that addresses the following question: how did racial protests in the mid-20th century change American law? That's the question that this book attempts to answer. So let me give a short description. Okay, well, what's the answer? What happened between approximately 1950 and 1970 in the law in response to protests against racial injustice? I'd say that 2/3 of my book deals with changes in substantive race relations law during that period. And there were three big changes, three big accomplishments. Number one, the invalidation of de jure segregation, the invalidation of policies, laws, state constitutions requiring people to be racially separated. Now, in the former Confederate states, the separation reached in every aspect of social life, from taxi cabs to schools to cemeteries to you name it. And this idea of separation, the theory under which this separation was promulgated, the theory under which this separation was justified, was the idea that this separation was totally innocent. There was nothing wrong with it. It was separate but equal. Nothing bad was being done to anybody. And indeed, the idea was that everybody was being treated equally. So let's, in South Carolina, my home state, let me read to you what the Constitution of South Carolina said the year I was born. And I was born in a very important year for my book, because I was born September 10th, 1954. A very important case that I'll mention in just a moment, Brown versus Board of Education. Brown versus Board of Education was announced on May 17th, 1954. But in 1954, this is what the Constitution of South Carolina said with respect to education. Separate schools shall be provided for children of the white and colored races, and no child of either race shall ever be permitted to attend a child for children of the other race. I emphasize, I like that, us folks in South Carolina, they were very punctilious, will ever, they weren't messing around. No child of either race shall ever be permitted to attend a school for children of the other race. Well, in May 17th, 1954, the Supreme Court struck down separate but equal, at least as applied to public education in primary schools and in secondary schools. Now, for the next decade, Brown versus Board of Education was enlarged. So May 17th, the Supreme Court says it's no longer permissible for states to separate people on a racial basis in public primary and secondary schools. Okay, well, that's schools. What about beaches? What about golf courses? Again, what about cemeteries? What about higher education? What about buses? All of these areas of social life became battlegrounds. And in my book, I talk about how the champions of racial justice had to fight in each of those domains. And I talk about the cases that they had to bring, or the protests that they had to bring. They attacked segregation in various ways, sometimes by boycotting, sometimes by demonstrating, sometimes by filing lawsuits. And I try to describe how in all these various domains there was a struggle. But again, to get back to my main point, one of the biggest accomplishments of this period was the invalidation of segregation. That was a huge, huge accomplishment, largely attributable to the lawyers associated with the NAACP Legal Defense Fund, the greatest of those lawyers being Mr. Civil Rights, the great Thurgood Marshall. All right, there was a second, what's the second big accomplishment? The second big accomplishment was to attack so-called private racial discrimination. Brown versus Board of Education strikes down segregation when it is accomplished through official, when it is accomplished through the state. But what about somebody who has a firm, and let's suppose that they say we're looking for workers, but we're just looking for white workers. We're looking for white workers. All the rest, if you're not white, don't apply. What about that? Or what about a hotel owner who has a sign, you're on the highway and the motel says, rooms available for white people. What about that? Again, that's not an official. It's not the state. That's a private actor engaging in racial discrimination. Or what about somebody selling a house and just says, my house is for sale, so long as you're white. Now, prior to the 1960s, in all of the situations that I mentioned, there was no federal prohibition on any of those racially discriminatory activities. In some states, there were state laws that might have prohibited that sort of racial discrimination. For instance, in California had a state law that prohibited those sorts of racially discriminatory actions. A state law that was way deficient, but we can get into that later. But in the South,
Randall Kennedy, Professor.
in the
Sorry, Professor Kennedy, you're on mute. Can you hit the unmute button?
Can you hear me now?
Yeah, we just had somebody join and I hit mute and
Okay.
I hit you on mute by mistake. Sorry.
Okay. So the second big accomplishment of the period between 1950 and 1970 was to push for federal legislation to prohibit private racial discrimination. So, 1964 Civil Rights Act prohibits Title II of the 1964 Civil Rights Act, which was probably the most controversial part of that act, prohibited private racial discrimination in places of public accommodation. Think restaurants, think motels, hotels, think theaters, things like that.
Information is the key when you make an informed.
So that was one of the big accomplishments. Title VII of the 1964 Civil Rights Act prohibited racial discrimination in large swaths of the private employment market. Not totally, but large swaths of it. And then in 1968, with the Open Housing Act, the Open Housing Act of 1968 provided federal legislation to outlaw racial discrimination in large sectors of the private housing market. So the attack on private racial discrimination was an important development in the period between 1950 and 1970. Third, the attack on racial disfranchisement. I mean, one of the most striking things about racial injustice in the mid-20th century was the extent to which in the former Confederate states, particularly the Deep South states, you had a situation in which Black people were largely excluded from the franchise. This happened in a variety of different ways. including just out and out terrorism. But there was also chicanery on a grand scale. All sorts of mechanisms were used to keep Black people from registering to vote, to keep Black people from becoming active participants in the electoral arena. And the 1965 Voting Rights Act, the designers of the 1965 Voting Rights Act created various mechanisms to attack racial disfranchisement. So those were sort of the three big achievements of this era. And I'd say that my book, really 2/3 of my book, is about those things. The victories and the defeats. There were defeats. I'll just leave it at that for now. But those were the three big victories. The last third of the book is about civil liberties because, how do you get this change? How do you get, how do you get change? Well, you get change through pushing, sometimes shoving. And when the racial reformers, when racial justice activists pushed for change, there was a reaction. The reaction of the segregationists, the reaction of the white supremacists was to attempt to suppress racial reformers. And when they tried to suppress racial reformers, that generated a tremendous amount of civil liberties litigation. And a third of the book is about the civil liberties litigation. The period between 1950 and 1970 was saw a tremendous blossoming of civil liberties in the United States. I'll mention just a couple just very quickly. Nowadays, if you join a political organization, and especially one that's marginal, highly unpopular, you might join a political organization, and you join it with the idea being that you can probably do so with a lot of confidence that your support of the organization will be closely held. It'll be confidential. Now, that's true. That's true. But where does that come from? Where does the idea of organizational privacy as a constitutional right, where does that come from? The seminal case, NAACP versus Alabama. Alabama hated the NAACP, tried to put it out of business, and in fact did succeed in putting it out of business in Alabama for 8 years. What Alabama did was they said, NAACP, you have failed to satisfy all of the rules that regulate nonprofit organizations in this state. And we're now going to investigate you and punish you. And in order to do that, we need to see your membership list. We need to know all of the people in Alabama who are members of the NAACP. And a judge said, listen, if you don't give up that membership list, not only am I going to say that you can't do business here, but I'm also going to fine you a tremendous amount of money. And this became an issue. What should the NAACP do? Well, the NAACP sued. They fought. They went to the Supreme Court a number of times. They finally prevailed. And one of the fruits of the NAACP's labor in this particular case was to create the idea of a federal constitutionally protected right to organizational privacy. Let me give you another example. Every day, you read the newspaper. I think your regular person sort of has a sense, intuits that when journalists discuss public officials, they have extra insulation. That even if the journalist makes a mistake, there's some degree of insulation in order to protect journalists, in order to give journalists breathing room. Well, where does that come from? That doesn't just come from no place. That comes from a case. New York Times versus Sullivan. There were people who were supporters of Martin Luther King Jr. who took out a paid advertisement in the pages of the New York Times. There were some errors in this advertisement. There were public officials in Alabama who sued the New York Times using state libel law. And what they wanted to do was to punish the New York Times and also dissuade news media from covering, the battles raging in the South. Well, the Supreme Court came to the aid of the New York Times and created a doctrine which says basically that news media outlets, when they're talking about public officials, they are protected with respect to state libel law, so long as they did not, purposefully lie, and so long as that they were not reckless with the truth. Again, a very important step forward in terms of civil liberties. Two others. One of my favorite cases of this period, civil liberties cases of this period, is a case called Edwards versus South Carolina. Like I told you, I'm from South Carolina. I'm from Columbia, South Carolina. And in the early 1960s, there came a point at which 187 students, Black students in Columbia, some of them were high school students, some of them were college students, they wanted to protest. They told the authorities, we want to give you due notice. We're going to protest at the South Carolina State grounds. That's the South Carolina State House grounds. We're going to be very disciplined. We're not going to block traffic, but we want our voices to be heard. We want to bring down Jim Crow. These 187 students march over to the State House. Everything is fine for about 40 minutes. And then some white people who, don't like what the students are saying start gathering. The police get a bit nervous. Then the police say to the students, hey, listen, you've marched for 40 minutes. We want you to stop. The leader of the students says, well, we've given notice. We're on this, grounds of the South Carolina State House. We're not we're not encroaching on anybody's rights. We simply want to be heard. And the police officer says, yeah, well, you've been heard. We're telling you to stop. In fact, we're going to give you 2 minutes. We're going to give you a couple of minutes, and you either disperse or we're going to arrest you. The students, showing tremendous discipline and tremendous tact, stand their ground. The police come to arrest them, and what do the students do? The students start singing. They start singing My Country 'Tis of Thee. They start singing the Star-Spangled Banner. They start singing their church hymns. All 187 are arrested. They're arrested for disorderly conduct. Their convictions are affirmed by the South Carolina Supreme Court. Lawyers for the NAACP Legal Defense Fund take their case to the Supreme Court of the United States. The Supreme Court of the United States, in an opinion by Potter Stewart, reverses and says this the way that the students exercise their First Amendment rights, Potter Stewart says this was an exercise of First Amendment rights, quote, in its most pristine form. The students completely won over the Supreme Court. The students won over even their adversaries. It was a great moment. One last one. You know, every day in the papers, you read about students and demonstrations and the law. Question: when did students get First Amendment rights? When did students at public universities first get judicially recognized federal constitutional rights? There's an answer to that. There is a case, the seminal case, Dixon versus Alabama, the Alabama Board of Education. There was a case in which black students in Alabama, at Alabama State College, protested a Jim Crow luncheonette in a state courthouse. Imagine that. A Jim Crow luncheonette in the early 1960s. This is after Brown versus Board of Education. The students engaged in a sit-in. The governor of the state heard about it and called up the president of the of Alabama State College and said, I want you to immediately dismiss, I want you to expel these students. Nine of the students were expelled. Up until that point, no court had recognized federal constitutional rights on behalf of students. And in fact, when the students had wonderful lawyers, they lost at a United States district court, but then they went on appeal to the Fifth Circuit Court of Appeals. And the Fifth Circuit Court of Appeals said, well, you know, these students are at least entitled to rudimentary due process. That was the beginning. That right there was the beginning of judicially recognized federal constitutional rights on behalf of students. So that's really that's what I've just gone over. That really covers my book. A couple of things, and then I'll subside. What are some special goodies that a reader will get out of reading my book? My book's a long book. This book is going to be 800 plus pages long. Very long book. And what will you get reading this book? Well, one thing I can say is you'll learn a lot of law. And you'll read about a lot of interesting cases. One of the things that I try to do, I talk about the big cases, the big constitutional cases. I want the readers to know about those cases. But I also have been on the lookout for the past 10 years for really interesting cases that people don't talk about very much. So I'm going to spend just 2 minutes telling you about the first thing that a reader will see picking up my book. I talk about a case called Hamilton versus Alabama. That's the first case that I talk about in the book. It begins the book. And here's the case. There was a 28-year-old activist, Mary Hamilton. She was from New York. She was in Alabama. She worked for the Congress of Racial Equality. She was an activist with CORE. She was arrested, protesting racial segregation. She was arrested. And at her trial, the state solicitor says to her, "Mary, why were you arrested?" And her response is, "My name is Miss Mary Hamilton." And the reason why she said that was because the solicitor referred to the white people by, their, Mr. or Ms. or, referred to them by their formal names. But the solicitor referred to her as Mary, and she wasn't having it. So then the solicitor says again, "Mary, why were you arrested?" And she responds by saying, "My name is Miss Mary Hamilton." At that point, the solicitor turns to the judge and says, "Judge, direct the witness to respond to my question. Her name is Mary Hamilton. I'm calling her Mary. Direct her to respond to my question." And the judge turns and says, "If you don't answer this question, I am going to immediately hold you in criminal contempt of court." Her response, "My name is Miss Mary Hamilton." The judge holds her in criminal contempt. She serves 60 days. Her lawyers, again, NAACP Legal Defense Fund lawyers, take her case on appeal. They lose in the state courts, but they take the case to the Supreme Court. The Supreme Court summarily reverses. One of the reasons I love that case is because it's so, you don't need to know a whole lot of law. It's not a complicated case doctrinally. It's a very simple case with facts that are highly memorable, vivid facts. I like that about it. And another thing I like about it is that it really brings home one of my major themes. One of the major themes of my book is the substance of symbolism. People often will put down symbolism, merely symbolic. Merely symbolic. People are willing to die for symbols. Rosa Parks, the people of Montgomery, Alabama, engaged in a year-long boycott because of an action that could be called symbolic. I mean, Rosa Parks, she was on the bus. You might say, well, her refusal to get up was merely symbolic. What does it matter if you're in one part of the bus as opposed to another part of the bus, so long as the bus takes you where you want to go? Well, it mattered to her. And it mattered to other people. Why? Because symbolism matters deeply in our social lives. So that's a big, theme that I play over and over and over and again in the book. And the case Hamilton versus Alabama really brings that home. Again, it's not you can go through law school and never hear about Hamilton versus Alabama, but I want people to hear about it. I've been talking long enough. I have other things to say, but I'd be very pleased to, take the conversation in long avenues that you all would like for me to address. So why don't I subside for now and field questions?
All right. Well, fantastic. That was really great, and we all appreciate it. I'm going to kick it off with the first question. There are a few already in the chat. If you do have questions, you can add them to the chat, and I'll get to them one by one. But my first question is just what was the impetus you had for writing this book? And you sort of got to it with the symbolism comment. What are you hoping that readers take away from it? What was missing out there that you're filling in?
Well, there's been this period of time. There's a very large literature, but no one has attempted to embrace this subject as comprehensively as I'm embracing it. I mean, let me put it like this. I describe and assess every imaginable, well, every racial controversy that generated legislation, litigation. I tackle. So just in terms of its breadth, it will be different. I also, oftentimes when people write about legal matters, especially for general audiences, and I write for a general audience. I mean, this book is going to be published by Knopf. All of my books have been published by, well, all of my previous books have been published by Pantheon, another Random House imprint, but they're for general readers. I mean, obviously, people in law school read them, but other people read them, and I want all sorts of people to read them, and I want all sorts of people to know about the law. The law is not, some sort of, it doesn't have to be mysterious. I think people ought to know about the laws under which, we live. And so I spend a lot of time describing in detail the legal ideas, the legal argumentation that that is at play in the creation of these laws, in the creation of statutes, the creation of the case law. And so I think that the detail that the amount of detail I think is rather unusual, but that's part of what I want to do. You asked about the impetus for this. This has been for me a labor of love. Why is it a labor of love? Well, one of the things that impels me and that frankly enthralls me. I mean, for over 10 years, I have been absolutely enthralled with this project. And one of the reasons is that it allows me to revisit people whom I have known. Some of the people are well known, some of them are not well known at all. So I'll start with some of the well-known people. I mentioned earlier on Brown versus Board of Education. If you were gonna, that was a big drama, Brown versus Board of Education. But if you had to choose the MVP, who would it be? Thurgood Marshall. I clerked for Thurgood Marshall, Justice Marshall, in the 1983 Supreme Court term. One of the great privileges of my life was going to the Supreme Court and being able to talk with Thurgood Marshall. And we talked a lot about what happened during this period. And so, I mean, I'm a sentimental person. When I go through this, there's a part of it that it brings back memories of being with Thurgood Marshall. The judge that I clerked for before I worked for Thurgood Marshall was a man by the name of J. Skelly Wright. J. Skelly Wright was, his main claim to fame was that as a United States District Court judge in the 1950s in New Orleans, he issued the first desegregation order of a major city in the Deep South. And the Louisiana legislature went completely berserk. He had to, there came a point at which he was threatening to hold in contempt the entire legislature, the attorney general. I mean, the whole Louisiana white establishment versus J. Skelly Wright. They had to put him under armed guard. I mean, it was a real thing for a number of years. When John F. Kennedy became president, the Kennedy administration wanted to basically, reward Judge Wright for his bravery. And they raised the idea of elevating, of promoting him to the Fifth Circuit Court of Appeals. And the Southern senators said, over our dead bodies, are you nuts? And so the Kennedy administration reached a compromise. They elevated Judge Wright to a Court of Appeals, but not in the South. He became a Court of Appeals judge in the District of Columbia. I worked for him when he was, Court of Appeals judge in the District of Columbia. And, I probably spend 40 pages of the book in a very detailed discussion of Bush versus Orleans Parish. And it's sort of sort of back and forth, Judge Wright versus, the Attorney General, the governor. I mean, it was again, it makes me feel good to revisit these people. One other person. Again, I mentioned I'm from South Carolina. The Thurgood Marshall of South Carolina was a man by the name of Matthew Perry. Matthew Perry went to a law school that was created virtually overnight. Why? Because the University of South Carolina Law School was for whites only, and when blacks threatened to sue, the state legislature said, oh, we'll create a separate but equal law school for Negro students. Yeah, we'll do that. We'll do it overnight. And they created a law school virtually overnight. The class that Matthew Perry went to law school with he had less than 10 fellow students. They went to a school that was, in the basement somewhere. They didn't have a library. They didn't even have their own, professors. Totally cast off. The great irony, and I love this is replayed over and over and over. I love this. So here were these black law students who were consigned to inferior facilities, viewed as inferior. And what happens? Matthew Perry works, creates a practice for himself, and becomes the leading civil rights attorney in South Carolina. And I know that when you went went to a demonstration in the 1960s in South Carolina, and you thought you might get arrested, you made sure that you had one piece of paper on you. You had a piece of paper with the telephone number of Matthew Perry and Lincoln Jenkins, his law partner. You made sure that you had their telephone number. I know this because my cousins were arrested, and they did place that call. And their lawyer was Matthew Perry. Matthew Perry in the 1950s and 1960s was the chief lawyer and civil rights lawyer. He was part and parcel of any racial controversy in South Carolina. To make a long story short, he has a great career. He becomes the first black federal judge in South Carolina. And today, if you have a federal case in Columbia, South Carolina, you go to the courthouse. you go to the Matthew Perry courthouse. I knew Matthew Perry. In fact, I used to steal figs out of Matthew Perry's fig tree in the front of his yard. He was very close friends with my aunt. And again, you ask the question, why do I want to write this? I want to write this because I want people to know. I want people to know about Matthew Perry. I want people to know about the great Julius Chambers. I want people to know about so many lawyers who, a lot of lawyers I talk about in my book, in this book, they didn't become judges. They didn't become big shots. People don't know their names, but under extraordinarily difficult circumstances, they did remarkable things. And one of the things that impels me is, I want people to know about them.
Great, fantastic. So I've got 5 questions in the chat. I don't know what your timing looks like, so I'm telling you this so you can pace your answers. If you do that long an answer for everybody, we'll be here for a while. But here we go. Deborah Myers asks, can you speak to the persistence, despite civil rights legislation, of racial disenfranchisement, housing segregation, educational segregation, and resource inequality?
Yeah. Well, there was a second Reconstruction. There was a tremendous amount of change. But do we still live in a society that is, in significant ways, a pigmentocracy? Yes, we do. I think that what people, one of the, I begin my book with 2 chapters. They're long chapters, but it stretches on for about, maybe 120 pages. And my book begins with, what was the situation in 1950? If you were a person who was interested in the race question in America in 1950, and you went from education to the administration of criminal justice to, to employment, wherever you went, what was the situation? What did politics look like? What did the law look like? I spent 120 pages talking about how awful it was in 1950. And by the way, 1950 was a lot better than 1900. So you ask, why is it that even with all that legislation, the problems that we confront are still so massive? Well, look at where we began. 1860, 1860 is not all that far away. It really isn't. And what was the situation in 1860? In 1860, you had 4 million Black people who had just been liberated from slavery, but who were people for whom it had been, in most of the slave states, it was a crime, a felony, to teach a slave to read or write. So in 1860, you have this mass of people who have been enslaved, who have suffered compelled illiteracy. The 13th, 14th, and 15th Amendments are promulgated and help to some degree, but then there's a tremendous reaction, and you then have the creation of the Jim Crow system. Black people were way, way, way down, and through a tremendous effort, a tremendous heroic effort, climbed up. But given how far down they were climbing up from, tremendous climb, absolutely extraordinary. But one has to recognize the tremendous gravitational pull of racism in American life. One has to recognize, just how difficult it is changing things. I want to go back to what am I trying to accomplish with this book? One of the things I'm trying to accomplish with this book is to show the difficulty of changing things even a little bit. I'm not talking about, this much. I'm not talking about a huge, this much requires just extraordinary persistence. And, I try to show just how difficult it is in the United States. It's a big country, huge, you have this huge land mass. Then you have, power is decentralized, federalism, you have, it's very limited. One of the things that surprised me, I must say, I feel almost embarrassed to say this because, I started this book, like I say, a little bit over 10 years ago, but when I started this book, I had been teaching. I had taught hundreds of students by the time I started this book. And it was only when I really got deep into this book that it occurred to me that our conception of the civil rights laws is we overgeneralize, we exaggerate them. Let me give you one example. At Harvard Law School, I taught many classes, many survey courses. And when we talk about the 1964 Civil Rights Act, I would say something like, well, Title VII of the 1964 Civil Rights Act prohibited racial discrimination in the private employment market. And I said that, and as a generality, that's okay. On the other hand, it actually exaggerates what Title VII did. It was only when I started writing this book, because, when you start writing a book and you sort of have to nail down everything, it really requires you to sort of examine, you re-examine and you look at things more closely. Title VII of the 1964 Civil Rights Act. Well, first of all, Title VII initially applied to workplaces that employed 25 or more workers. Now, the main street in front of Harvard Law School, Massachusetts Avenue. I walk down Massachusetts Avenue and I'm looking at, the little businesses. There are a whole lot of businesses that don't have 25 people. Lots. Title VII doesn't apply to them. Millions, so there were millions of workers, or places that Title VII didn't embrace. It was not the coverage of Title VII as initially designed was considerably narrower than than certainly I had in mind, and that a lot of commentators have had in mind. Then I took another look. I said, well, geez, Title VII initially, the first year, was limited to places that had 100 or more workers. Then the second year, it was 75 or more workers. Then the next year, it was 50. Title VII did not take full effect for 4 years. It wasn't immediate. It was, it was rolled out. It was much narrower than people thought. And lots of civil rights legislation is like that. I mentioned at the outset, the Open Housing Act of 1968. Now, I think as a general matter, if you were to read, a report about the 1968 Open Housing Act, you might read the newspaper and they say, well, the 1968 Open Housing Act prohibits racial discrimination in the private housing market. No, not really. It exempts, the 1968 Open Housing Act exempted lots of private housing, particularly owner-occupied housing. Now, it might seem like those are just little technicalities, but, added up, those technicalities really amount to a whole lot. And that's part of the reason why, we are in the position that we're in today.
Okay,
Randy,
next,
this,
Alfredo Barrios asks, great talk. Brown versus Board of Education, in some ways, the culmination of a long effort by the NAACP to battle separate but equal over a number of years. Can you speak about some of the cases that Brown built on, like Mendez v. Westminster, a federal case out of California?
Sure. Brown versus Board of Education did. Mendez was a case, it's a very interesting case because it's a case that involved Mexican Americans. And some of the arguments that, in a sense, were used in Brown were rehearsed in Mendez. Now, I talk about Mendez it's an interesting thing. On the one hand, it's a case that, yes, presages Brown versus Board of Education. It's also an interesting case insofar as it draws our attention to some of the complications of the race line. So, question, are Mexican Americans white or are Mexican Americans people of color? Up until the mid-1960s, the major groups that protected and sought to advance the rights of Mexican Americans viewed Mexican Americans, and in fact insisted that Mexican Americans view themselves as white. And in fact, one of the criticisms, when they bring cases would be, gosh, there's segregation. And, segregation's one thing if you're segregating, Asian Americans. If you're segregating Negroes, well, okay, we might not like it, but we can understand that. But hell, we're white and you're segregating us. That's unjust. It wasn't until the mid-1960s that the champions of Mexican American liberation decided to change things and actually revisit the question of whether they were white or people of color. And here, it just goes to show you how things turn. The Mexican American Legal Defense and Education Fund, where does that come from? MALDEF is modeled on the NAACP Legal Defense Fund, and the NAACP and the person who was very largely responsible for helping to organize MALDEF was the longtime leader of the NAACP Legal Defense Fund, Jack Greenberg. So, again, getting back to your question, why am I so interested in? I'm so interested. There's so many interesting little nooks and crannies involved here. So many controversies. So for instance, Jack Greenberg, I knew Jack Greenberg. I knew Jack Greenberg. Jack Greenberg offered me a job at the NAACP Legal Defense Fund, and I was headed there. I worked at the NAACP Legal Defense Fund after my first year of law school. I spent a summer at 10 Columbus Circle at the LDF. It was the most important thing that happened to me professionally during my law school years. It turned me on to the law. I think the world of Jack Greenberg. And, there was a big controversy involved, Jack, when Thurgood Marshall stepped down as the head of the Legal Defense Fund to become a judge. There was a big controversy. Well, who's going to take Thurgood Marshall's place as the leader of the Legal Defense Fund? And there were a couple of people who were, suitable candidates. It really came down to two. Jack Greenberg, white, Jewish. The other person was a wonderful lawyer by the name of Robert L. Carter, who became a federal judge himself in the Southern District of New York. Thurgood Marshall gave the nod to Greenberg. Greenberg becomes his successor, but it became something of a controversy. And when I rehearsed this, I talk about this in my book, because there were people who said, geez, we don't like this so much. I mean, this is the NAACP Legal Defense Fund. Shouldn't a black lawyer be the head of the Legal Defense Fund? It created a real controversy, and I talk about stuff like that. And in fact, I talk about all sorts of controversies, and I'm sure that there will be people who will criticize, different positions that I take. But there's no controversy in this area that I let alone. So, Black Power, big issue. 1966. You got Martin Luther King, and you got his his challenger by his side, Stokely Carmichael. They both respected one another. They both liked one another. But they had, they came to a parting of the ways with respect to, certain aims, certain means. There was a real, dividing line. And one of the things that I think is going to be sort of interesting about my book is, if you go into a lot of colleges today and talk about this period between 1950 and 1970, a lot of people writing about this subject, at Harvard and other places, Yale, Princeton, other lots, fancy, Emory, I don't care, places, UCLA. The cool kids are Carmichael, Malcolm X, Huey Newton for sure, the Panthers. Those are the cool kids. Not in my book. In my book, the cool kids are Thurgood Marshall, A. Philip Randolph, Bayard Rustin, John Lewis, and I'm sure that that's going to be controversial. And I talk about the pros and cons, but I talk about that. I talk about the riots. I talk about rioting was a very important development. I mean, some of you, I can tell from the screen that some of you are of an age that you will remember the long, hot summers. And now when people talk about the long, hot summers, there's something, in my view, of an apology, a defense of the long, hot summers, the riots. I'm extremely critical of the riots. I think that they were a moral and political disaster. And I try to make the argument for that proposition. I'm sure that there are going to be some people who are going to take me up on that and not like it. But, I push that point. And again, these are things that matter a whole lot to me. It's grappling with that sort of thing that makes this project, an interesting one for me.
Got it. So we got 3 more questions.
Fine.
Alfred Smith, thank you for supervising my 3rd-year paper on the Civil Rights Act of 1866. It was a great honor to work with you and learn from you. Can you share your thoughts on the recent executive orders seeking to eliminate diversity, equity, and inclusion programs?
Sure. First of all, it's good to hear from you. Thank you very much. Off screen, shoot me an email. I'd like to know about, how things have been going with you. So you know how to get in touch with me. Get in touch with me.
I sure will. Thank you.
Listen, I think that what's happening is awful. Okay. I think that, and in particular, it's sort of interesting. So, the last few days, front page has been the use by the Trump administration of Title VI of what? Of the 1964 Civil Rights Act. So this was a device, the turning off of the federal spigot was a device that was going to be used against segregationist states that refused to desegregate. Now, interestingly enough, back then in 1964, the segregationists were very successful in putting into the legislation, putting into Title VI, procedural requirements that the federal government would have to follow before withholding funds from institutions. Has that been done? No, that has not been done. And so you have the federal government today using a civil rights statute, or I should say misusing a federal civil rights statute, for reasons that I think are, no pun intended, trumped up. And, I'm horror-stricken by what's going on with respect to higher education. Higher education has never been in more jeopardy than today. And by the way, I say that with the 1950s and McCarthyism in mind. What is happening right now is much more dangerous, much more ominous than what happened in the 1950s. And what happened in the 1950s, much of what happened was, bad. But what's going on now is even more ominous. But please get in touch with me.
Okay, 2 more. Daniel Wolf says, your examples of the expansion of civil liberties are terrific, but they may continue to bear the weight of our reliance on them and on the legal environment they created only if governments continue to honor and obey courts and precedents. One of the issues that concerns me in this current Trump-Musk context is the breakdown of the norms the government officials will comply with laws that limit their scope of activity. For example, DOJ's armed invasion of the National Endowment for Democracy, which is an independent agency. Whether or not the courts eventually find that to be legal, I'm concerned that motivated government officials will take from this the idea they can take such actions with impunity and simply take the knocks later. I don't expect you to tell us what we should do, but I'd appreciate your thoughts about the issue of adherence to norms and how we might enforce those norms.
Yeah, well, I mean, there are rights on parchment. There are rights, in some some state or federal constitutional provision. Those rights only take root through conduct. So you're absolutely right. You're absolutely correct in drawing our attention to the idea of norms, the idea of expectations, the ideas of, what do people do? And one of the things that is so concerning is the way in which we have officials who are acting in ways that, they're giving the finger to deeply entrenched, or what we thought were deeply entrenched expectations and norms. What are we going to, what is to be done? People have to raise their voices about it. People have to raise their voices about it. So here's, among the many things, there's so many troubling things going on. It's hard to keep your eye on any particular one because there's so many. But one thing that's occurred in the last few days that's, been in the news, the attack on the private bar. So this idea of the government, the administration blacklisting law firms and trying to intimidate lawyers. Now, it's an open question how this thing is going to play out. But it seems to me that any hope of this playing out in a good way, in a satisfactory way, in a minimally tolerable way, will have to include lawyers standing up. So, I was listening to a podcast 2 days ago. They were talking about this law firm that had been basically blacklisted, and the law firm wanted to sue the government, but it was having difficulty finding lawyers that would take the law firm's case. A lot of law firms were really very afraid. And then, but pretty quickly, there was a law firm that said, sure, we'll take your case. And that acted like we're used to seeing law firms act. That law firm, by the way, Williams and Connolly. Williams and Connolly said, we'll take your case. And they did. And they got, and thus far, they've gotten some positive results. We're going to have to see people, and every one of us, by the way, I don't care who you are, I don't care where you are, every one of us is in some place where they can say something. The people, people who have bigger platforms can be heard more. People who have more power can have more influence, but all of us have some degree of influence, and we're all going to have to speak up. And lawyers are going to have to, speak up and be counted. Just like, by the way, academics are our leaders of academic institutions are going to have to speak up. I was very proud yesterday to read, I think it was in the Atlantic magazine, a piece by the president of Princeton University, Christopher Eisgruber. And it wasn't a long piece, but he wasn't beating around the bush. And he was talking about how threatening the present administration is, and how higher education needs to respond more vigorously. That is going to have to happen. People are going to have to act. We're going to have to speak. We're going to have to conduct ourselves in such a way as to reinvigorate norms, reinvigorate expectations that, are written down someplace, but if they're not acted on, they're going to wither and die.
Okay, last question. Timberly Williams says, thank you for your talk today, Mr. Kennedy. I thoroughly enjoyed it. Looking at today's racial justice movements, do you see parallels between the legal battles of the civil rights era and today's struggles? In what way do you think the role of law and protest has evolved?
Sure, I see. Sure, there are parallels. I mean, um, some of the protests in the racial justice area of, in recent times have built upon um, earlier protests. Um, so, there are analogies to be made. I guess one thing that, um, you know, the law is all around us. The law is very important. I think that, and again, why am I interested in, spending all my time writing something, 800 plus pages? I think that this history that I'm traversing actually does generate narratives, generate chronicles, generate lessons that can be put to very good use. And in this moment, this will be my last comment, and then, I'll let, everybody get on about their business. But I do think it's pertinent for this moment, this, in my view, very ominous moment. My year working for Thurgood Marshall, late in the spring of the year, there was an execution that took place. Marshall thought the death penalty was unconstitutional under all circumstances. And I think what the execution that I have in mind, he wrote a particular dissent. And I remember coming in the next day and I said to him, Judge, I often call him Judge. I said, Judge, geez, on the things that matter most to you, you're typically on the losing side. I mean, people read your dissents, but they're dissents. You're on the losing side. Aren't you discouraged? And he told me two things that I have held close ever since. And I think that people who are interested now in struggles for social justice ought to hold on to. Number one, he said, no, I am not discouraged. This is not a sprint. It is a marathon. That was point one. Point two was even more poignant. Point two, he said to me, knucklehead. He called all of his clerks knuckleheads. That was just a term of endearment. He said, knucklehead. He said, you're real young. You got to remember that for most of my time as a practicing attorney, Plessy versus Ferguson was an affirmative case for me. Separate but equal. Most of my time as a practicing attorney was figuring out ways to squeeze as much equality out of that lying formula as possible. And he squeezed a lot of equality out of that lying formula. I think today, people ought to remember that. People ought to remember that, first of all, change is possible, and you've got to be inventive in creating change. And sometimes sometimes you got to use, you can't go straight. Sometimes you got to go to the side. Sometimes you got to take 2 steps back. Marshall did those things. And, one of the reasons why I venerate him so is, you take a look over his lifetime, remarkable change under very difficult circumstances. And we are all of us are the better for what he did and for the spirit that he showed and for the poise and discipline and just good sense and just, just again, to get back to your initial question, what animates me? Well, thinking about that animates me. And I want in this book to bring across to readers the possibilities that people like Marshall were able to realize. Hey,
Well,
thanks an awful lot.
Thank you. I think we've seen ample evidence of animation, and we really appreciate it. I mean, this is a good example of why we do these events, because it gives us, an hour and a half that reminds us of what we had when we were at Harvard and don't have anymore, which is exposure in even brief amounts to people like you. And we're very, very appreciative of it. So thank you for taking hour and a half of your time this evening to spend with us here in LA. And I can say this was a fantastic hour and a half. I think everybody in the group will share my opinion, which is this was one of the best times they've had doing this in any of the speaker series, and we really do appreciate your enthusiasm and your time.
Thank you very much. Be well.
All right.
Thank you.
Thank you.
Thank you.